Hello friends. In this part, we will discuss about two very important aspects of a valid contract, that is offer and acceptance. In fact, offer and acceptance are two ingredients which may be treated as the base of whole of the contract. First of all, we will discuss about the meaning of an offer and legal rules related with it. Then we will understand what may be the different types of offer. Then we will discuss the another aspect, that is acceptance. What is the meaning and what are legal rules for acceptance. And then we will discuss something about communication of offer and communication of acceptance. The very first issue is meaning and legal rules related with the offer. At the outset, we need to consider one thing, that word proposal and word offer, they mean one and same thing, and that's why these can be used interchangeably. Meaning of offer. We can very easily see that offer is the very first activity which goes into making of a contract. So what exactly is the meaning of the term offer in the eyes of law? Section 2, Clause A of the Contract Act defines the term offer as when a person signifies his willingness to do or not to do something, to remain abstain from doing anything or to do anything, with a view to obtain the acceptance of other person for such act or such abstinence. The first person is said to have made an offer to another person. Let's analyze this definition in little bit detail. We can see that as per the law, the offer must have two basic ingredients. First of all, there must be an expression of willingness. Now this willingness may be for doing something, or it may be for not doing something. Say for example, X offers to sell something to Y for a particular amount. This is an expression of a willingness for doing something. And the bank offers not to file a court case if the borrower pays the outstanding amount. This is an expression of willingness for not doing something. So for offer, the expression of willingness is needed, which may be a positive or it may be a negative willingness. The another requirement is this willingness must be expressed with a view to obtain consent of other party. Say for example, if somebody is saying that I may think of selling my car if somebody offers me rupees 1 lakh. This statement cannot be treated as an offer because there is no intention of getting acceptance of other party in this case. So even if other party offers the amount desired, that will not be treated a valid offer on the part of first party. No contract shall get created in this case. So two basic ingredients, expression of willingness and a view to obtain consent of other party are necessary to make it a valid offer. After discussing meaning of the term offer, let's see what are various legal rules related with the offer. The very first rule is that the offer must be given with an intention to create a legal relationship between both the parties. A social invitation which is not intended to create legal relationship amongst the parties is not a valid offer. A very good example may be inviting somebody over a cup of coffee. Now this is not an offer in the eyes of law, because it is not intended to create legal relationship amongst the parties. The next requirement is that terms and conditions of the offer must be definite, must be certain, should not be vague. Say for example, Mr. A is having 3 cars and he asks to Mr. B, "Are you ready to purchase my car for rupees 2 lakhs?" Now this is an offer which is uncertain because Mr. A, the offerer, is not mentioning which car he intends to sell. This is an uncertain offer and that's why shall not be treated as a valid offer. A very important rule related with the offer is that the offer must be communicated to another party. An offer to be complete must be communicated to other person. If other person has accepted the offer in ignorance of the offer, then this will not be treated as a valid acceptance and it will not confer any right on the acceptor. A very important court decision in this matter is in case of Lalman versus Gauri Dutt, where G has sent his servant L in search of his missing nephew. Subsequently, G has announced a reward for information concerning the boy. L brought back the missing boy without the knowledge of reward. It has been held by the court that there was no contract between L and G and L cannot claim the reward. It cannot be said that he has accepted the offer because offer has never been communicated to G. So very important rule, that is the offer must be communicated, then only it can be accepted and can convert into a valid contract. The next rule related with the offer is that offer should not contain a term the non-compliance of which may be assumed to be the acceptance. The offer cannot be designed in such a manner that if other party does not communicate anything, this may be treated as an acceptance. The person making the offer cannot say that if acceptance is not communicated within a certain time, the offer would be considered as an accepted. There has to be an opt-in offer rather than opt-out offer. Say for example, Mr. A offers his motorcycle to B for rupees 20,000 and tells him that if B does not say anything within 15 days, it will be treated as if he has accepted the offer of A. This offer is not valid because in this case, not doing something by other party is being treated as an acceptance, which is not correct. Now let's see what may be different types of offer. An offer may be an express offer, an implied offer, it may be a specific offer, or it may be a general offer. In next few slides, we will be discussing each one of these types of offer in little bit detail. The first type of offer is an express offer. What is an express offer? Very simply, when an offer has been made by words spoken or written, it is called express offer. Say for example, when A says to B, "Will you purchase my house at Chennai for rupees 3 lakhs?" Now this is an express offer made by A to B in words spoken or written. As against express offer, we may have implied offer. Now what is an implied offer? Express offer has been made with words spoken or written. On the contrary, implied offer is implied from the conduct of the parties or from the circumstances of the case. An example should be useful to understand this concept clearly. When a transport company runs a bus on a particular route, there is an implied offer by the transport company to carry the passengers from one place to another for a certain fare. The acceptance of the offer is complete as soon as the passenger boards the bus. No written agreement takes place between these two parties, but still there is a valid contract. There was an implied offer by the transport company which has been accepted by the passenger by boarding the bus. Another way of seeing the offers as specific offer and general offer. A specific offer is something which is made to a specific definite certain person. The rule is this: a specific offer can be accepted only by the person to whom it is made. If somebody else accepts this offer, this will not create a valid contract. Say for example, if Mr. A asks to Mr. B to purchase his blue car for rupees 2 lakhs, third party Mr. C cannot accept this offer because it was a specific offer. But as against a specific offer, we may have general offer. As the name itself suggests, the general offer is an offer made to general public, to the world at large, and anybody with the knowledge of offer can accept the general offer. It is necessary to distinguish the offer from certain other concepts, that is an announcement or an invitation to make an offer. An announcement, a declaration by a person that he intends to do something, creates no right of action in favor of another. This declaration only means that an offer is going to be made in near future. Say for example, if a company calls for CVs of various persons for the post, it doesn't mean that he is giving any offer. It only shows that the company shall be making an offer later on to the person who has been selected. Right now it is only an announcement. Similarly, display of goods by the shopkeeper with a price marked on the item does not mean that shopkeeper is interested to sell that particular item or he is offering to sell that particular item. It is rather asking public to give him an offer to purchase the goods at the price which has been displayed in the showroom. So an offer is different from an announcement and an invitation to make offer. Another related concept in this case is when somebody calls a tender. Tender is basically an invitation to make an offer, and when somebody submits a tender, then that other party actually makes the offer. Say for example, when A invites tender for supply of something, X, Y and Z submit the tender. A accepts the tender submitted by X. Now a valid contract is created between A and X. Y and Z have only submitted their offer in the form of tender, which has not been accepted by A, and that's why no contract has been created between A and Y or between A and Z. After understanding the concept of offer from various angles, let's now discuss another very important ingredient of a valid contract, that is acceptance. In fact, it is offer and acceptance of the offer which makes a valid contract essentially. So in case of acceptance, we will be discussing what is the meaning of acceptance, and then we will talk about various rules which are required to create a legal acceptance. First of all, what do we mean by an acceptance? When a person to whom the proposal, the offer is made, signifies his assent thereto, the proposal is said to be accepted. So basically it is conveying the assent by the offeree to the offerer which creates an acceptance, and then the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So it is offer by one party and its acceptance by another party which makes a promise. Now let's discuss certain legal rules related with an acceptance. These are the rules which are required to be followed in order to create a valid acceptance. If there is a breach of any of these rules, the acceptance shall not be treated as a valid acceptance, and accordingly no valid contract shall be created. The very first requirement for creating a legal acceptance is that the acceptance must be absolute, complete and unconditional. Then only that will be binding. This acceptance must be to all the terms of the offer. Any conditional acceptance is not a valid acceptance. Say for example, Mr. A offers his car to Mr. B for rupees 50,000. B accepts the offer and pays rupees 49,000 in cash and promises to pay balance of rupees 1,000 by tomorrow. This is not a valid acceptance by Mr. B because this acceptance is conditional, not an absolute one. This will not create a valid contract between Mr. A and Mr. B. Mr. A does not get bound by the conditional acceptance given by Mr. B. The next requirement is that the conditional must be given in the prescribed mode. If offerer has prescribed any specific mode in which he desires the acceptance, then the acceptance must be in that mode only, then only it will be treated as a valid acceptance. However, if no specific mode has been prescribed, then the acceptance must be given in some usual or reasonable mode which is used in the normal course of business. If the acceptance is not according to this mode, this will not be treated as a valid acceptance, and then there will not be any contract between two parties. Say for example, if A offers something to B and says that if you accept the offer, reply by email. B accepts the offer but sends the reply by post. Now this is not a valid acceptance. A has specified a prescribed mode in which he desires the acceptance. B has not given the acceptance in that particular mode, and that's why this acceptance shall not be treated as a valid acceptance. A does not get bound by his promise in this case. For creating a valid acceptance, it is also required that it must be given by the same party to whom the offer is made. In earlier part, we have discussed something called specific offer, where offer is made to a particular person, and then it is required that if the offer has been made only to a specific person, that person should only give the consent, should only give the acceptance. If it is accepted by any other person, then this will not be a valid acceptance. And then the acceptance must be given in a reasonable time. Now what may be a reasonable time? It is possible that offerer himself might have specified a time limit in the proposal, in the offer. Then it will become very necessary that acceptance is given within that particular time period. However, if no time limit is specified by the offer, then the acceptance must be given within a reasonable time. What will be a reasonable time? That will depend upon facts and circumstances of every case. Say for example, a very important leading case law in this case is Ramsgate Victoria Hotel Company versus Monteflore. In this, Mr. M offered to take shares in our company on 8th of June. He received a letter of acceptance from our company on 23rd of November. 8th of June, the offer has been made. 23rd of November it has been accepted. Mr. M has refused to take the shares. Company claimed there is a valid contract between both of them, and that's why Mr. M cannot go back from his promise. It has been held by court that Mr. M was entitled to refuse as his offer has not been accepted by the company within a reasonable time period. So it is very necessary that acceptance must be communicated within the specified time period if any mentioned by offerer. If no time period has been mentioned by offerer, still it has to be given within a reasonable normal time period. Another issue related with a valid acceptance is that once the offer has been rejected, it cannot be accepted by the offeree later on. Unless the offerer renews the offer once rejected can never be accepted by the offeree subsequently. A valid acceptance cannot be implied from the silence. In our discussion about offer also, we have discussed that offer should not contain any condition, the non-compliance of which may be treated as an acceptance. So, for example, if an offer is saying that if other party doesn't reply within 15 days, this will be treated as acceptance of offer, but this is not a valid acceptance. The law says the acceptance of offer cannot be implied from the silence of the offeree. However, if the offeree by his previous conduct inducted that his silence means the acceptance, if offeree himself has mentioned earlier that if I fail to reply within 15 days, this may be treated as my acceptance, then this will be a valid kind of acceptance. Otherwise, normally acceptance has to be communicated by some positive mode, by doing something. Simple silence on the part of offeree can not be treated as valid acceptance generally. After understanding meaning and legal rules related with the offer and acceptance, now we will discuss the legal requirements related with the communication of offer and communication of acceptance. We shall try to understand when the communication of offer and acceptance is considered as complete in the eyes of law, and when an offer and acceptance can be revoked by the concerned party. This is what we shall be discussing in the next slides. The provision regarding communication of an offer is that the communication of a proposal, communication of an offer is complete when it comes to the knowledge of the person to whom it is made. So one person has made an offer. This will be treated as communicated to another person when that another person, that offeree, comes to the knowledge of this proposal, this offer. This is what has been prescribed by Section 4 of the Contracts Act. Say for example, Mr. A proposes to sell a house to Mr. B at a certain price, and Mr. A has written a letter to Mr. B in this regard. The letter has been posted by Mr. A on 10th of July. It reaches to Mr. B on 12th of July. The communication of offer shall be treated as complete when Mr. B receives this letter, that is on 12th of July. So, very simply, communication of an offer is complete when it comes to the knowledge of the person to whom it has been made. When communication of an acceptance is complete, the issue regarding communication of acceptance is required to be examined from two different angles. One, from the angle of the proposer, the person who has made the offer, and two, from the angle of the person to whom it has been made, who is going to accept the offer. Law says, section 4, that communication of an acceptance is complete is against the proposer when it has been put into such a mode of transmission so that acceptor cannot take it back, so as to be out of the power of acceptor whenever the communication of acceptance has been made in such a manner that it is now out of the power of acceptor to take it back. This will be treated as completed against the proposer. However, so far as acceptor is concerned, the communication of acceptance shall be treated as complete only when it comes to the knowledge of the proposer. When acceptor has simply put it into a mode of transmission, this communication is complete so far as proposer is concerned, but with respect to acceptor, this will be treated as complete only when this acceptance comes to the knowledge of the proposer. An example should be of help here. Let's continue the example which we have seen earlier, where Mr. A has made an offer to Mr. B by post. Now Mr. B accepts the offer of Mr. A by a letter sent by post on 13th of July, which reaches to the proposer on 15th of July. Now in this case, so far as Mr. A is concerned, the acceptance is complete when the letter has been posted, that is on 13th of July. Now it is beyond the control of Mr. B, and that's why on 13th itself acceptance communication is complete so far as Mr. A is concerned. However, for Mr. B, the communication of acceptance shall be treated as complete only when it is received by Mr. A, that is on 15th of July. So, communication of acceptance, two different angles. Completion so far as proposer is concerned when acceptor has sent it to the proposer. Completion so far as acceptor is concerned, complete when it comes to the knowledge of the proposer. Based on earlier discussion, let's now try to understand what will happen if the letter of acceptance gets lost in transit. In earlier slide, we have seen that still he cannot say that since there was no acceptance, I will not be bound by the contract. Contract is complete the moment acceptance has been posted by the acceptor. However, in order to bind the offerer, it will be important that letter of acceptance has been correctly addressed, adequately stamped, and actually posted by the acceptor. If acceptor has not communicated the acceptance in a proper manner, he has not posted that letter in a proper manner, then the acceptance shall not be treated as complete. So the moral of story is this, that if the offerer has not received the letter of acceptance, since it has been lost in post, however, offeree acceptor has posted it correctly, the contract shall be treated as complete and offerer proposer shall be bound by that contract. After the communication of proposal and acceptance, now we shall be understanding something about revocation of proposal and acceptance, how and when a proposal can be revoked by the proposer, and similarly how and when the acceptance can be revoked by the acceptor. First of all, what is the meaning of revocation? Simply speaking, revocation means taking back or withdrawal or cancellation. So revocation of proposal means withdrawal of proposal, cancellation of proposal by the proposer, and revocation of acceptance means taking back the acceptance, cancelling the acceptance by the acceptor. What is the time for revocation? So far as revocation of a proposal is concerned, the law says a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer and not afterwards. The moment offer has been accepted by the offeree and communication of acceptance is complete so far as proposer is concerned, the power of proposer to revoke the proposal shall get extinguished. He will not be able to revoke the offer now onwards. In earlier part, we have already discussed the rule regarding completion of communication of acceptance as against the proposer. So, taking that example further, now let's understand the issue related with the revocation of proposal. Mr. A has sent a letter to Mr. B offering to sell his house. The letter has been posted on 1st. Mr. B accepted the proposal again by another letter sent by post on 4th. This letter reaches to Mr. A on 6th. Now, communication of offer of Mr. A was by through post. This offer has been accepted by Mr. B through post on 4th. The acceptance of offer is complete so far as Mr. A is concerned on 4th. Even if he has received the letter on 6th, still the communication of acceptance is treated on 4th. He cannot withdraw his offer or after the date of 4th. This is what is the requirement of law, that when the communication of acceptance of offer is complete as against the proposal cannot be withdrawn afterwards. After understanding time for revocation of proposal, let's discuss what is the time for revocation of acceptance. If the offeree acceptor wants to revoke his acceptance, till when he can do so. Law says an acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor, not afterwards. This means till the communication of acceptance is complete as against the acceptor shall have a power to revoke his acceptance. Once this communication gets completed, he will not have any power to revoke the acceptance. Taking the example of earlier slide forward, Mr. B may revoke his acceptance at any time before 6th. This is the date on which letter of acceptance has reached to Mr. A, and as per law, on this date the acceptance shall be deemed to be communicated to the offerer as against the acceptor. In revocation, the first issue is the time of revocation, that is up till when a proposal or an acceptance can be revoked. This we have discussed in earlier slides. Now, the another issue is how proposal or acceptance can be revoked. Law says the revocation can be done by communicating the notice of revocation. Simply, offerer can give notice of revocation to offeree. However, as discussed earlier, this notice has to be given before the acceptance is complete as against the offerer. Say for example, if at an auction sale, A makes the highest bid of these goods. This is, A has made an offer to purchase the goods of B at a particular price. He may withdraw the bid before the fall of hammer. In case of an auction, the fall of hammer is considered to be communication of acceptance. The offer can be revoked only before the acceptance. Another way in which an offer gets revoked is by lapse of time. If the time is fixed in the offer, then the offer shall be treated as cancelled when this fixed time is over. However, if no fixed time has been mentioned in the offer, it shall be treated as revoked after the reasonable time. If acceptance has not been communicated within this reasonable time, the offer shall be treated as cancelled as revoked. Say for example, Mr. A sells on Thursday something to a purchaser and gave him 3 days time to accept. The purchaser accepted the offer on Monday. Since 3 days time period has already expired, the offer shall be deemed to have been lapsed, revoked, and if Mr. A has sold that item to somebody else, Mr. B shall not have any claim against Mr. A in this regard. So, if the offer has not been accepted within the specified time period or within a reasonable time period, it shall be treated as if it has been revoked. If there is a condition precedent to the acceptance for the offeree and offeree has not fulfilled that condition, then also offer shall be treated as revoked. Say for example, Mr. S has made an offer to Mr. B subject to the condition that Mr. B is required to pay the agreed price before a certain date. If Mr. B fails to pay the price before that particular date, he has failed to fulfill the condition precedent to the acceptance, and now the offer shall be treated as cancelled as withdrawn by the offerer. An offer also gets revoked due to death or insanity of the offerer. However, in this case it is required that offeree, the acceptor, comes to know about this before the acceptance. If he accepts the offer in ignorance of the death or insanity of the offerer, then the acceptance shall be treated as a valid acceptance. And now it is time to summarize everything we have discussed about offer and acceptance. The very basic requirement is this, that a valid contract requires a valid offer and a valid acceptance. An offer is expression of willingness to do or not to do something. The offer must be given with an intention to create a legal relationship, it must be definite, it must be communicated, and it should not contain any term the non-compliance of which may be treated as acceptance. The offer may be express, implied, specific, or general. The offer is different from an announcement or an invitation to make an offer. An acceptance must be unconditional, must be given in the prescribed mode, or if no mode has been prescribed, then in some reasonable mode. It must be given by the parties to whom the offer is made. It must be given in a reasonable time. And finally, acceptance cannot be implied from the silence. Communication of a proposal is complete when it comes to the knowledge of the offeree. However, communication of an acceptance is complete for proposal when it is put in a course of transmission to him so as to be out of the power of acceptor, and communication of acceptance is complete for acceptor when the acceptance comes to the knowledge of the proposer. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer. and an acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor. A proposal gets revoked by communicating the notice of revocation. It gets revoked by lapse of time. It may get revoked by non-fulfillment by the offeree of a condition which was precedent to the acceptance, and a proposal also gets revoked by the death or insanity of the offerer if the offeree comes to know about it before the acceptance. Thank you.